do think it is helpful from what we did here today, what we did not hear today, is that this really is a matter of law. Whether a statute is unconstitutional on its face has to be a question of law, because as this court knows, it enjoined the statute before it came into effect. So there are no facts that are relevant to the facial challenge itself. And that's why we think it is the best course of action than to go ahead and decide in the merits and make a definitive statement one way or another to instruct the legislature or anywhere else that the bill is either unconstitutional or it's not. But it's a legal matter that can be decided today. The last thing I'll say, what we do know is we don't need discovery in a jury trial. They're not facts to be resolved. It is a question of law. Secondly, Your Honor, to provide, I think, to bring us back to what House Bill 2 did and what it did not. Because I think what plaintiffs are doing is attempting to make this a mess when everybody knows what House Bill 2 did and what it did not do. Before House Bill 2 was enacted, or if we put it this way, the change of House Bill 2 is two things. It very narrowly defined conceit. Now, if we remember, Section 9737(1) makes it a crime to carry a weapon that is concealed unless you have a permit. There is no statute on the books that says it is a crime per se to openly carry. Now, there's an important asterisk there that I'll get to in a moment. But in terms of conceit, the law is clear. If you carry concealed, you must have a permit or you are violating the law. So what House Bill 2 did was say that is a concealed carry permit. And it very narrowly defined concealed, such that if the weapon is visible, or as long as it's not hidden from common observation, then it's not concealed. And you don't need a permit. The easiest way to think about this, Your Honor, is if you or anyone else can see enough of the weapon to understand that is a weapon, then it's not concealed. It's open.
So House Bill 2 does more than merely defines concealed. It does away with the permit.
Your Honor, it makes it clear that the permit is only required for concealment. You are correct to say that after House Bill 2 was passed, it has now become abundantly clear. I don't think the legislature would say they were changing the law, but I will grant you this. They made it very clear that after House Bill 2, that the concealed weapon permit applies only to concealed carry. That you do not need a permit, and maybe this is the clearest way to state it, Your Honor. You do not need a permit from the state of Mississippi to carry open. Now, in terms of the question of is that confusing? Is that vague? Are people unsure of what that House Bill 2 does? Your Honor, if I may approach. Your Honor, this is a copy of the motion for temporary restraining order. This was the first document that was filed in this case. And I highlighted on page 3, Roman numeral 8 and 9. This is plaintiff's understanding on June 28th of what the bill did. House Bill 2 amends the current law to allow individuals to legally carry weapons in plain view without a permit. That's a fairly accurate statement of the law. The second part is, under this bill, the weapon may be loaded or unloaded as long as the weapon may be observed for common observation. An individual may carry a weapon in a holster which is only partially visible. So all sides are actually in fairly close agreement. What House Bill 2 said is, it clarified, if you're carrying open, if people can see the gun, if it is not, according to plaintiffs, as long as it's within plain view, you don't need a permit.
So when you say clarify, explain that to me. Was there some confusion before House Bill 2?
I don't think there was, Your Honor. I think that there is, with respect to the officer's testimony in the moment ago, I've heard many folks tell me that if you see someone, that they would ask police officers, well, I saw someone carrying a weapon just openly. just if you would, out in the open, there's no question, you can see it. Did that violate any law? And the argument was, well, no, we don't have a permit requirement for open carry. I think this, though, House bill made it absolutely clear. It resolved any doubt that your permit is only required to carry concealed. But, Your Honor, here is the big disagreement. Here is the issue that I think this is where plaintiffs and the state disagree. Plaintiffs then are concerned that, okay, by exempting you from a permit, if you're going to carry open, then the rest of the laws regarding what you can do with a weapon have somehow been repealed. Let me give an example, and the officer gave us a good example a moment ago. There are criminal statutes right now that are out there that prohibit you from being drunk and in public. Right? And so, if before House Bill 2, if officers see someone drunk and in public, that's a violation of criminal law. They can arrest them. If they see someone drunk and in public and carrying a weapon in plain view, you can still arrest them. Now, what you won't charge them for is carrying a concealed weapon, because it's not concealed. But
Can you arrest them for carrying a weapon?
not for carrying a weapon. With the law they violated, because you don't need a permit to carry open, but what you can arrest them for is being intoxicated in public. In other words, having a weapon on you is not a get-out-of-jail-free card for any of the other laws that prohibit particular conduct. Maybe some other examples, Your Honor, I think would be helpful, probably provide some background. There was a question a moment ago about, okay, you don't need assuming, as we said for House Bill 2, you don't need a permit under Mississippi law to carry open. Does that mean that someone who is mentally defective, that's actually statutory, can carry? Well, no. Federal law prohibits an individual who has been adjudicated to be mentally defective from possessing a gun at all. That's, we cited in our brief to you, that's 18 U.S.C. Section 922G. Under federal law, felons, and I say possess, meaning if you can't possess, means you can't carry open, you can't carry concealed. Federal law prohibits felons, fugitives. It also prohibits those who are using unlawful controlled substances, those who have been adjudicated mentally defective, someone who is discharged honorably, dishonorably from the military, someone that is subject to a restraining order or has been convicted of misdemeanor domestic violence, cannot even under federal law possess